Hey y'all, it's Kim. So yesterday was not the best day, but anyway, I didn't do hardly anything. I had to edit a video because YouTube sent me an Instagram. So I was just like kind of ticked off with them. But anyway, this is going to be, it's basically like Ghislaine Maxwell and Virginia Giuffre. It's an appeals court document disclosure. I think somebody was trying to sue to get some of this stuff put out in the public. Right here, this is going through old case law to see, I guess basically proving that this stuff should be made available to the public or something along those lines. So that's kind of the context here. But anyway, we're on page 76, and this is a 2024 page document. It may be some of it repeated over and over, but who knows? I've seen a few things in here that's kind of a little different. But anyway, so we're going to start here. It says the Immuno AG Court of Appeals held that Article 1, Section 8 of the New York Constitution required a multidimensional approach to the determination whether an allegedly defamatory statement constitutes constitutionally protected opinion. The court gave, numerous reasons. New York's expansive constitutional guarantee of speech was formulated and adopted before the application of the First Amendment to the states. It has long been our standard in defamation actions to consider factors beyond whether facts are verifiable, and the court was concerned that if type speech is to be construed narrowly, insufficient protection may be accorded to central values protected by the law of this state. And then the Immuno AG court reaffirmed that where a defendant alleges that the subject statement is opinion, Stein-Hilber supplies the analytical framework, or Steinhilber, whatever, held that whether an allegedly defamatory statement is fact or non-actionable opinion should be decided based on four factors: an assessment of whether the specific language in issue has a precise meaning which is readily understood, or whether it is indefinite and ambiguous; a determination of whether the statement is capable of being objectively characterized as true or false; an examination of the full context of the communication in which this statement appears; and a consideration of the broader social context or setting surrounding the communication, including the existence of any applicable customs or conventions which might signal to readers or listeners that what is being read or heard is likely to be an opinion, not fact. An application of these factors to the January 2015 statement compels the conclusion that the allegedly defamatory words, phrases, and clauses are non-actionable opinion. Whether the specific language in issue has a precise meaning which is readily understood, or whether it is indefinite and ambiguous. The three sentences plaintiffs alleges are defamatory or indefinite and ambiguous. The first says plaintiff's allegations against Ms. Maxwell are untrue, but plaintiff has made many dozens of allegations against Ms. Maxwell, and some are provably false. See this motion at 37 to 50. The statement does not specify which of the allegations are untrue. The second statement is that the original allegations have been shown to be untrue. The original allegations were first revealed in the 2011 Churcher articles. Plaintiff made many dozens of allegations originally. The statement does not specify which of the original allegations were shown to be untrue, and some have been shown to be untrue. See this motion at 53 through 65. The third statement is that plaintiff's claims are obvious lies. This too is indefinite and ambiguous. Plaintiff has made many dozens of claims. The statement does not specify which ones are being referenced. More importantly, it does not say how or why some of the claims are obvious lies. Regardless, some of plaintiff's claims are obvious lies. See this motion at 53 through 65. Whether the three sentences in the January 2015 statement are capable of being objectively characterized as true or false. Can the three sentences be characterized as true or false? They cannot, because the statement does not specify which of the many dozens of allegations plaintiff has made are untrue and shown to be untrue, and which of plaintiff's many dozens of claims are obvious lies. It is axiomatic that the plural form of a word, e.g., allegations and claims, universally denotes only more than one. People versus Cox's, maybe. Lehman Brothers Commercial Corp versus Min Metals International Non-Ferrous Metals Trading Company. And then, let's see, so for Steinhilber purposes, it is dispositive of the fact versus opinion question if we can identify two instances in which plaintiff's allegations or claims are incapable of being proved true or false. Such examples abound. It cannot be proven true or false whether Miss Maxwell appreciated the immunity granted under the Epstein plea agreement or whether she acted as a madam for Epstein. That is because these are plaintiff's counsel's arguments or opinions. The January 2015 statement asserts that these allegations or claims are false or obvious lies. That assertion cannot be proven true or false under Steinhilber. The full context of the communication in which the statement appears. The factor is often the key consideration in categorizing a statement as fact or opinion. Davis versus Boheim. And then that was in New York, 2014. So, in deciding whether a statement is defamatory, the words must be construed in the context of the entire statement or publication as a whole, tested against the understanding of the average reader. Aronson versus Wiersma, or Wiersma, something like that. In the Accord, Elias versus Rolling Stone LLC. And then that was in June of 2016. It is the duty of the court in an action for libel to understand the publication in the same manner that others would naturally do. The construction which it behooves a court of justice to put on a publication which is alleged to be libelous is to be derived as well from the expression used as from the whole scope and apparent object of the writer. James versus Gannett Company. And then according to Chow, whatever, versus Lewis, and that was 2013. In general, the trial court should view allegedly defamatory statements from the perspective of the average member of the public. Statements directed to a specific audience, however, are considered from the viewpoint of that audience. Instructive is the court's analysis of the perspective from which it should assess an allegedly defamatory article on boxing published to sports readers. The issue of how the average reader would construe this statement is certainly a fair one, for the question of whether statements are defamatory turns on how the audience to whom the statements are addressed would interpret them. As the New York State Court of Appeals has explained in a boxing defamation case, the words are to be construed not with the close precision expected from lawyers and judges, but as they would be read and understood by the public to which they are addressed. Here, the statements in question were addressed to readers of an internet boxing website and the sports page of daily newspapers. The statements must be considered from this viewpoint, as Judge Martin held in Horn versus Matthews, and that was in 1997. An article on the sports page of a newspaper should be viewed from the perspective of the audience to whom it is addressed, i.e., the understanding of a sophisticated and sports conscious reader. Dibella versus Hopkins, and this is 2002. Okay, the entire email containing the January 2015 statement from Mr. Gao sent to various media representatives reads, to whom it may concern, please find attached a quotable statement on behalf of Ms. Maxwell. No further communication will be provided by her on this matter. Thanks for your understanding and the best Ross Gout acuity reputation. Jane Doe 3 is Virginia Roberts, and they screwed this up again, but I guess they never corrected it. So, anyway, so not a new individual. The allegations made by Victoria Roberts against Ghislaine Maxwell are untrue. The original allegations are not new and have been fully responded to and shown to be untrue. Each time the story is retold, it changes with new serious, salacious details about public figures and world leaders, and now it is alleged by Miss Roberts that Alan Dershowitz is involved in having sexual relations with her, which he denies. Miss Roberts' claims are obvious lies and should be treated as such and not publicized as news, as they are defamatory. Ghislaine Maxwell's original response to the lies and defamatory claims remains the same. Maxwell strongly denies allegations of an unsavory nature, which have appeared in the British press. Sorry, I screwed that up. And elsewhere, it reserves her right to seek redress at the repetition of such old defamatory claims. Exhibit F, italics and underscoring applied, whatever. So plaintiff listed the underscored clauses, phrases in the complaint as the deliberate falsehoods, document 1 at 30, and false and defamatory statements at 32. Plaintiff is suing on. As discussed above, it is improper to remove from their context and isolate allegedly defamatory words, phrases, and clauses of sentences from an allegedly defamatory publication. Instead, the allegedly defamatory words, phrases, and clauses must be construed in the context of the entire statement or publication as a whole, considered from the whole scope and apparent object of the writer, and viewed from the perspective of the audience to whom it is addressed. This statement was directed at a discrete member of some 30 members of the media in reply to their request for a response from Ms. Maxwell to Ms. Giuffre's CVRA joinder motion. Mr. Bodden, who prepared Barden, I was thinking of that Dr. Bodden, Michael Bodden, Anyway, Mr. Barden, who prepared the January 2015 statement, did not intend the January 2015 statement to be a traditional press release solely to disseminate information to the media, Exhibit K at 15. So he did not request that Mr. Gao or any other public relations specialist prepare the statement. Instead, Mr. Gao served only as Mr. Barden's conduit to the media representatives who have requested a response to the joinder motion allegations and who Mr. Barden believed might republish those allegations. Mr. Barden intended this statement to mitigate the harm to Ms. Maxwell's reputation from the press's public or republication of plaintiffs' false allegations. He believes this could be accomplished by suggesting to the media that, among other things, they should subject plaintiffs' allegations to inquiry and scrutiny. For example, he noted that plaintiffs' allegations change dramatically over time, suggesting that they are obvious lies and therefore should not be published as news or publicized as news. Mr. Barden also intended the January 2015 statement to be a shot across the bow of the media, which he believed have been unduly eager to publish plaintiffs' allegations without conducting any inquiry of their own. And then, so Mr. Barden stated repeatedly that plaintiffs' allegations were defamatory. In this sense, the statement was very much intended as a cease and desist letter to the media recipients, letting the media recipients understand the seriousness with which Ms. Maxwell considered the publication of plaintiffs' obviously false allegations and the legal indefensibility of their own conduct. Consistent with Mr. Barden's purposes for the statement, Mr. Gao's email prefaced the statement with the following phrase: "Please find attached a quotable statement on behalf of Ms. Maxwell." And then the statement was intended to be a single, one-time only, comprehensive response quoted in full to plaintiffs' December 30th, 2014 allegations that would give the media Miss Maxwell's response. The purpose of the prefatory statement was to inform the media recipients of this intent. We note that plaintiff in her complaint makes the same mistakes as the Steinhilber plaintiff, extracting words and phrases from their opinion context so that she can claim the assertion of a defamatory fact. That is not permissible. See Steinhilber 501. And then the sentence which plaintiff selects from the message and claims is factually laden, impugning her as lacking in talent, ambition, and initiative, is preceded and followed by statements which are clearly part of the attempt at humor prevailing throughout. The broader social context or setting surrounding the communication, including the existence of any applicable customs or conventions, which might signal to readers that what is being read is likely to be opinion and not fact. This factor is concerned with the factual background leading up to the preparation of the statement. It is a critical factor here. In December 2014, plaintiff and her lawyers had timed for maximum effect during the slow news cycle between Christmas and New Year's Day, the public filing of a superfluous motion filled with salacious and provocative allegations of sexual abuse and sexual trafficking involving wealthy and prominent Americans. Plaintiff deliberately placed Miss Maxwell in the middle of the abuse and trafficking, alleging that she recruited plaintiff into the sexual abuse trafficking scheme and engaged in numerous criminal acts. Importantly, 3 years earlier, when plaintiff was interviewed extensively by Churcher for 2 lengthy articles published in March of 2011, plaintiff's allegations concerning Miss Maxwell were very much different. In the articles discussing plaintiff's shocking account of being sexually exploited by Epstein, Prince Andrew, and Epstein's male peers, plaintiff made virtually none of what Judge Mara found were unnecessary and lurid details about how Miss Maxwell allegedly subjected her to sexual abuse and trafficking. After plaintiff filed a CVRA motion, some 30 reporters contacted Miss Maxwell's press representative, Mr. Gow, for Mr. Maxwell or Miss Maxwell's response. As Miss Maxwell's lawyer, Mr. Barden undertook that task, relying on his knowledge of the 2011 articles, publishing plaintiff's allegations, and drawing on his experience and training as a lawyer. Mr. Barden crafted a response with the goal of discrediting plaintiff and what the statement called plaintiff's new allegations. To that end, Mr. Barden contrasted plaintiff's old allegations from 2011 with the new 2014 allegations. The second paragraph of the statement is indicative of this strategy. Each time the story is retold, it changes with new salacious details about public figures and world leaders, and now it is alleged by Ms. Giuffre that Alan Dershowitz is involved in having sexual relations with her, which he denies. Exhibit F, having established the dramatic difference between these sets of allegations, suggesting plaintiff was fabricating more and more salacious allegations as she had more time to manufacture them. Mr. Barden added the third paragraph. Ms. Giuffre's claims are obvious lies and should be treated as such and not publicized as news as they are defamatory. Mr. Barden's arguments constitute pure opinion. Steinhilber, they take established and revealed facts, plaintiff's modest 2011 allegations to a newspaper reporter, and plaintiff's expansive, unnecessary, and lurid 2014 allegations in a motion to open the door to criminal prosecutions of and civil lawsuits against wealthy and prominent men around the world, to draw an obvious inference that plaintiff was more truthful in the 2011 articles and engaged in massive manufacturing of fiction in the 2014 joinder motion. There's no limit to the subject matters on which pure opinions may be expressed. with constitutional immunity, including whether a person believes another is lying or is a liar. And then Independent Living Aids versus Maxi Aids Inc. They got a summary judgment, and then read in the context of the entire article, Zaretsky's remarks called Sandler and others liars can only be understood as a denial of their accusations. Even the most careless reader must have perceived that the words were no more than rhetorical hyperbole, a vigorous epithet used by Zaretsky, who considered himself unfairly treated and sought to bring what he alleged were the true facts to the readers. The epithet liar is the context, standing by itself, merely expressed the opinion that anyone who persisted in accusing Zaretsky of improper business practices could not be telling the truth. Since the basis for this opinion was fully set forth, the communication of Zaretsky's views cannot be libelous. Citations, whatever. Okay, so this is Gross versus New York Times. That was from 93. Even when uttered or published in a serious tone, accusations of criminality could be regarded as mere hypothesis and therefore not actionable if the facts on which they are based are fully and accurately set forth and it is clear to the reasonable reader that the accusation is merely a personal surmise built upon those facts. In all cases, whether the challenged remark concerns criminality or some other defamatory category, the courts are obliged to consider the communication as a whole, as well as its immediate and broader social context, to determine whether the reasonable listener is likely to understand the remark as an assertion of provable fact. Mr. Barton's inference from disclosed facts qualifies as pure opinion, Steinhilber, and then accordingly that Mr. Barton characterized plaintiff's 2014 allegations harshly as obvious lies, as opposed to untruths or some softer term of no moment. What? Under New York law, pure opinion is not actionable because expressions of opinion as opposed to assertions of fact are deemed privileged and no matter how offensive cannot be subject of a action for defamation. And Radijak versus Brewster Fire Department Inc. of the Brewster SC Joint Fire District, I guess, or distribution, I don't know. And then according with Man versus Abel. Okay, so the drawing of such inferences would be constitutionally protected under or even under the standards of the First Amendment that are less protective of opinion than is Article 1, Section 8 of the New York Constitution. See Adelson versus Harris. In determining whether a statement constitutes constitutionally protected opinion, courts also look to the specific context of the statement. When looking at a statement's specific context, of particular importance is the principle that when an author outlines the facts available to him, thus making it clear that the challenge statements represent his own interpretation of those facts and leaving the reader free to draw his own conclusions, those statements are generally protected by the First Amendment. The application of the four Steinhilber factors confirms that the three phrases and or clauses plaintiff alleges are defamatory or in fact part of a statement that taken as a whole constitutes non-actionable opinion. The premise of plaintiff's complaint is that once she is able to identify references in the January 2015 statement to any assertion of fact that potentially is subject to proof, e.g. the truth or falsity of her many dozens of allegations, old and new, then she has a very viable defamation claim. That ignores the teaching of Steinhilber and Immuno AG, as the Steinhilber court held. Even apparent statements of facts may assume the character of statements of opinion and thus be privileged when made in public debate, heated labor dispute, or other circumstances in which an audience may anticipate the use of epithets, fiery rhetoric, or hyperbole. See gross, and anyway. We stress once again our commitment to avoiding the hyper-technical parsing of written and spoken words for the purpose of identifying possible facts that might from the basis of sustainable liable action. And then quoting Immuno AG. And then to the same effect, and is this court's citation to a Louisiana Supreme Court decision for the proposition that words which taken by themselves would appear to be a positive allegation of fact may be shown by the context to be a mere expression of opinion or argumentative influence. And then Adelson, let's see, and then it's quoting Mashburn versus Collin. So see, it's just going through a bunch of case law at this point to argue for the facts here. Okay, I know this part's a little boring, but anyway, I'm not an attorney, so I don't really understand how they gather all this information because there's no way you would know all these court cases. But anyway, so we'll just finish with this. It also is important to take into account, as Steinhilber requires, that Mr. Barton was directing the January 2015 statement to a discrete number of media representatives who are aware of plaintiff's original and new joinder motion allegations and who are requesting a response from Ms. Maxwell to the new allegations. These newspaper reporters and other media representatives would have the point Mr. Barton was making, the opinion he was expressing, namely, that there was a good reason to believe plaintiff was fabricating allegations for her purposes. In the context of the media circus that ensued, the public filing of the joinder motion and the media's repeated and insistent request for an immediate response from Ms. Maxwell, it is highly unlikely any media recipients of the January 2015 statement expected anything other than a statement equivalent to the March 2011 statement condemning the allegations, and it is highly likely all the media recipients understood the statement to be a forceful argument that plaintiff's shifting and inconsistent stories about what allegedly happened rendered her inherently unbelievable and proved her increasingly provocative and lurid allegations were obvious lies. These are precisely the messages Mr. Barton sent to them. The general nature of Mr. Barton's assertions or allegations, original allegations and claims, the distinction between plaintiff's original and new allegations, and the inferences he drew from comparing the original and new allegations together powerfully demonstrate that the January 2015 statement was nothing more than an opinion. All right, I'm going to stop it here. Like I said, this gets a little bogged down and boring, but it is what it is. I think there was some other stuff in here that's probably going to get a little spicy and maybe get some more context into people's lives. We'll see. Anyway, I'll talk to y'all later. Have a good one. Bye.